Okay, let's talk about obscenity. Obscenity is defined on page 7. Well, the case that defines obscenity is on page 748 if you're following along in Chopra. When it comes to obscenity, you really need to know the Miller test. Miller is the case, Miller versus California, on obscenity from the United States Supreme Court. Number one, when it comes to issue spotting, once again, this is not terribly complicated. If the fact pattern has nothing to do with sexually explicit material, then it's not an obscenity problem. Don't get tricked into saying that something is obscene just because it's just absolutely gross or disgusting, right? Gross and disgusting under U.S. constitutional law does not constitute obscene unless it has something to do with sex. So you've got to keep that in mind. Here's a little bit of a brain teaser. This almost sounds like an LSAT trick, but you do have to keep this in mind and let this marinate until it sinks in. Because obscenity is always sexual material, sexually explicit, all obscenity is pornographic, because the definition of pornographic is sexually explicit. But not all pornography is obscene. So let me say that again. All obscenity is pornographic, right, meaning sexually explicit, but not all material that's pornographic is obscene. So not all sexually explicit material rises to the level of obscenity, which, to remind you, is unprotected speech, right? The court is going to be pretty careful about calling something obscene, since that loses all of its First Amendment protection. So what that means is that if you have material that's sexually explicit, it has to rise to a certain level of, off the wall, before a court would say that it's obscene. So let's talk about that. Now, on page 749, towards the bottom, but you could pull up the Miller case, on Westlaw or Lexis and follow along. You'll see that the Supreme Court says that there are 3 elements to obscenity. So first of all, it's good news. We have elements here. But the bad news is that when the Supreme Court says there's 3 elements, that's pretty sloppy. They break it down into A, B, and C, but what we see is that each one of the elements that the court lays out breaks down into elements itself, right? There's multiple things going on under each element. So I'm going to run through these bullet points. When you see sexually explicit material on an exam, that's your cue that you're probably being tested on obscenity, and then you have to apply this test. So let's take a look at it. Number 1. In these cases, courts apply a reasonable person standard, and that makes perfect sense. When it comes to judging whether material is beyond the pale, you might be able to hear Laney taking a drink of water, sorry about that. But when it comes to that, you don't want these decisions being made by somebody who's a prude, and you also don't want this decision being made by somebody who is not capable of being shocked. I don't know if you have friends like that. I do have friends like that. It doesn't matter what you show them, what they hear, what they see, they're incapable of being shocked by anything. That's not the kind of person you want making that decision. Now, my grandmother, again, just on the prude side of things, my grandmother hated living in Arizona because she thought that cactus was an obscene thing because of something that she thought about cacti. So we don't want grandma who thinks that cacti are obscene. We don't want that person making these decisions either. So number 1, reasonable person standard, right? Average person, normal sensibilities. Number 2, the court has recognized that standards change. So you apply a contemporary standard to what material is obscene. And contemporary, of course, means modern day. We're not going back. Here you don't do the originalist thing, right? We're not going to go back to the 1800s, 1700s, when showing some ankle was considered obscene, right? We're talking about modern standards. Third, community standards. The court also recognizes that different parts of the country have different approaches to what goes too far in terms of sexually explicit material. What's acceptable in New York or Los Angeles might not be acceptable in Meridian, Mississippi, and that's not to judge any one of those places for. Hi, Lainey. Hi, are you curious? Do you want to know some common law? Huh? Okay. I'm doing baby talk now on a law school video. So anyway, here's the thing you want to know about community standards. Community standards means, it can mean a part of a state, like in Florida, kind of breaks up into different areas. You've got South Florida, you've got Miami, you've got sort of the I-4 corridor where Tampa is, and you've got up on the Panhandle, much more conservative. So a judge could instruct a jury that the community standard to be applied is something like that, the city of Miami or South Florida or northern Florida or the I-4 corridor. What a judge cannot do is instruct a jury that the community is something bigger than a state. So, in other words, you cannot say New England, right? There's no New England standard. New England is not, it's a region, not a state. There's no Midwestern standard. That's a region, not a state. There's no Southeastern standard or Deep South standard. Those are regions, not states. So be careful of that. Community standard means nothing bigger than the state. So I want to back up here. Reasonable person standard, contemporary community standards, now and in the area where you live. Fourth, you can't get a conviction on obscenity, and here we're usually talking about either possession or distribution, right, of obscenity, obscene material, unless the obscenity or what is considered obscene is specifically defined in the applicable local statute or ordinance. That means that if the ordinance says something like it's unlawful to have disgusting sexual material or icky or some kind of vague term like that, that is not going to do. Courts want legislatures and city councils and bodies like that to be very specific about what they think is obscene, so that people who are selling material that's sexually explicit this has to do with notice, are on notice of what's legal and what's illegal. So it has to be specifically defined in the statute, which means a well-drafted obscenity statute or obscenity ordinance is itself going to be almost obscene, because it will describe, right, acts or situations in great detail that are obscene. Next, the trier of fact, the court says, would have to find that the material taken as a whole appeals to the prurient interest. And prurient is a word that most of us don't use in our common everyday lives, so you need to know what that means and know how to spell it as well. P-R-U-R-I-E-N-T. Not purient, not puritanical, that would be the opposite. Prurient interest. Prurient interest is a shameful or morbid interest in sex, right? That goes well beyond, one justice actually said, that goes well beyond good old-fashioned normal sex, whatever that would mean. The prurient interest would be unusual, sick, shameful, morbid interest in sex. Now, note also that I said taken as a whole, right? The courts insist that you take the work as a whole. So if it's a magazine, the entire magazine. If it's a video, the entire video. If it's a website, the entire website. That's what you're judging. You're not going to. Court is not going to hold that a book is obscene because there's one description in the book of a shameful or morbid interest in sex, right? If the rest of the book has some literary value, then you have to take that into account. You also have to find, and this is a related point, the jury would have to find, or the fact finder would have to find, that the material is patently offensive. Note the word patently. Patently means obviously, clearly, starkly offensive. Finally, the prosecutor would have to show, succeed under what lawyers and law students call the SLAPS test. The prosecutor would have to show that the material has no serious literary, artistic, political, or scientific value. You need to think about all those words: literary, literature, artistic, obviously, art. Political or scientific value, right? If something is kind of gross and sexual and goes beyond the pale, but it's said in a political context, then you fail the SLAPS test, right? Then the prosecutor would fail the SLAPS test because that has serious political value. Scientific value, watch out for science journals, right? Science journals journals that are used for psychology and psychiatry in particular, those will describe and even depict very sick behaviors that have to do with sex. But if there's scientific value to it, then it's not obscene. One more thing about the SLAPS test. While the entire rest of the Miller test right? Which if you look at the way Miller lays it out, would be A and B, right? They lay it out as three elements, right? A, B, and C. A and B under the Miller test, as stated in the Miller case, again, you apply a community standard. The SLAPS test applies a national standard because the court has said, or courts have said, that what constitutes literature or art or science or politics, right, and particularly science, right, and great literature, those do not change depending on where you live. So we judge whether something has, again, literary, artistic, political, or scientific value, serious, right, value as to one of those things by a national standard. As to child pornography, number one, if real children are used in sexually explicit depictions, in a case called Ferber that is in your book on page 915, the court says, if real children or real minors are used in the production of that kind of material, sexually explicit pornographic material, then A and B under Miller are presumed, and the prosecutor does not have to show that. In other words, it's presumed that it appeals to the prurient interest and is patently offensive, right, applying contemporary community standards. So the prosecutor does not have to show that. However, the prosecutor would still have to show, right, that there's no literary, artistic, scientific, or political value, the SLAPS test, because we want to make sure that if these depictions are, especially in a scientific journal or something like that, that doesn't get caught up in obscenity. It makes sense, I think, that there's a presumption that child pornography is sick and deranged. Now, in another case called Ashcroft, which is in the Chopra book at page 764, Justice Kennedy said, if real children are not being used in the depiction, if it's digital imagery or something like that, and of course that's getting more sophisticated every year and every month. If there aren't actual children being used in the depictions, then that presumption goes away. Now that doesn't mean a prosecutor can't get a conviction. It means the prosecutor would have to actually prove the entire Miller test, right? The interest in giving prosecutors a presumption on A and B under the Miller, as stated in the Miller case, is to protect actual children. If there are no actual children being used, the prosecutor's back to the regular standard, has to prove everything we just went through. Reasonable person standard, contemporary community standards, sexual depiction or description specifically defined in the statute or ordinance, that the work as a whole appeals to the prurient interest, is patently offensive, and lacks serious literary, artistic, political, or scientific value. So that is obscenity. You have to know those elements. You have to apply all of them, look for facts about each one, and be aware of the child pornography nuance, right, that kind of tags on to the end of your obscenity analysis. If you see anything there about child pornography, is it real kids or is it not, right, that determines what the right answer is if you see child pornography. Okay, next up we're going to do a little reasoning exercise, but that covers unprotected speech. Unprotected speech is incitement, fighting words, and obscenity. If speech does not fit into one of those three categories, then it is protected speech. After we do the reasoning exercise, then and a few problems, then we're going to have to turn to the other two big excuses, right? The time, place, manner test and the O'Brien symbolic speech test that I discussed in earlier videos. So we will pick it up there. Again, a couple of exercises to come up, and then we'll talk about time, place, manner, and O'Brien.